I was the most crucial aspect of my submission was respect to how we look at Article 368 and the procedure for making a constitutional amendment. So there are three kinds of situations where a court may make a declaration that the legal instrument is void. First is a case where a constitutional amendment is declared void, either because the procedure has not been followed or because of constituent incompetence. What I've coined to make a distinction from legislative incompetence, because 368(1) talks of constituent power. So it has described itself as a constituent exercise. And doctrine of basic structure really means that the constituent power does not contain the power, or it does not enable the Parliament by the special procedure to destroy or emasculate the basic features of the Constitution. So it was a case of constituent incompetence. That would be a case where the provision or entire bill or a particular provision of the bill, in this case section 4 and 55, which were introduced by the 42nd Amendment Bill, they will have to be treated as if they were never there. It goes out of the bill. There is a distinction between the procedure of ordinary lawmaking power and 368. Here, the terms of the bill become part of the Constitution itself. The expression, thereupon the Constitution shall stand amended in accordance with the terms of the bill. Because of parliamentary procedure, they say that once it has been assented by the president, it becomes a constitutional amendment act. But 368 doesn't envisage any such thing. The moment the bill is passed and assented, the Constitution stands amended in terms of the bill. And in para 75 for Minerva Mill, what was struck down was section 4. As far as we are concerned, section 4 of the bill. And in as much as the declaration would operate retrospectively from the very inception, that is the date when the assent was given by the president. For paragraph 75 of Minerva Bill does not contain any limitation with respect to its declaration. It doesn't say it will not be retroactive, or it will be retroactive with certain conditions. Yes, madam.
381 says amendment in terms of the bill after it is passed. Suppose after discussion in the Parliament or the Legislature, there is some change proposed in that.
Some change in the...
Change proposed in the bill. Some language is proposed to be changed.
I'm sorry, I couldn't get...
Some bill is presented. After discussion in the Parliament,
yes,
some change is proposed.
Yes.
In the language. Now that change is never made in the bill, it will come only in the act. Now the language says in terms of the bill, and the parliament says,
If an amendment is proposed and the amendment is passed by the parliament, it will be treated to be a part of the bill itself then. That's my humble response was.
Because the amendment is proposed before the bill is
Passed.
converted into an act.
Yes. So during debate, somebody will move a motion
that shall be deemed to be.
that it, instead of, like as we Lordship saw in the Constituent Assembly, there were K.T. Shah and other members, they moved amendments. So before it is put to vote, finally, either the proposer of the bill, or in this case the government, they will, somebody who is moving the bill will accept it, or it will be referred to select committee. It will go there and come back with a recommendation. So the bill will be ultimately passed either defeating the amendment or not approving the amendment, and then it becomes part of the bill itself. Therefore, this theory which the petitioners rely upon, that once it is declared by the court do not have legislative power, there is not repeal, all these things are actually completely foreign to the structure and phraseology of Article 368. They don't fit in there. Either the Constitution stands amended or it does not stand amended. These are the two situations only. Once the declaration is of its void, then we should not to adopt the principle of East End dwelling. Should not allow the mind to boggle. Just because there is a gap in the proceedings of the court and the declaration comes after a certain period of a certain lapse of time. This case, Minerva Mills case, 9 years time. So certain things happen. Court may save it. Court may say it will be retroactivity, but whatever has been done will not be disturbed. Or as in Indra Shani's case, the Lordship still went a little further in crafting. So the court today acts scientifically like a surgeon. It may involve grafting. As in Indra Shani, Lordship said, it's promotions, reservation in promotion, not permissible, but this will operate 5 years hence. So from a later date. So as I said in Golaknath, where they propounded the principle of prospective overruling, that the courts, we should shed the impression that the courts do not make law. The courts do make law. And the very doctrine of basic structure is something which has emerged from the pen of the court. So the courts are making law. Interregnum legislation, interstitial legislation, filling in the gap. There are so many forms in which the court today is, and very rightly,
Shortly put, it is called judge-made law.
Judge-made law. So therefore,
Sometimes as a critique.
now, to bank upon Keshav Madhav Menon and all those earlier cases in the 50s, Peshi Kaka and so on, to hark back to those and bring them back on the table for discourse. Today, it's well accepted, well entrenched that the courts do make law. And so therefore the courts, if the court can say that our declaration will not operate backwards, it will save something, it will be treated as if in the past it was operating. Lordships can say that until this date it operates, but hereafter it will not, because we have declared it to be void. So all these things show that once the declaration is there, that declaration operates, in this case, being unrestricted, unqualified, it will go back to the root. It is as if it was never there. it is as if the Constitution never stood amended in terms of Section 4 of the 42nd Constitutional Amendment Bill. So this is constituent incompetence. Now this stands on a stronger footing than legislative incompetence, where the state legislature or parliament may trench upon the exclusive field of the other legislature. Even in that case, all these judgments which my learned friends have referred, even though they are of the 1950s, they have took caution to say that if the defect is of legislative incompetence, and I'll show that when I refer to those judgments, then they are void ab initio, of no effect. So this court has distinguished between a case of legislative incompetence and while an invalidity arising out of breach of either fundamental rights or some other constitutional provision.
Article 368 specifically refers to constituent power.
Yes.
I think that is why you are coining the phrase constitutional incompetence. Constituent incompetence. Now, legislative incompetence, you are differing. And is it because one is trying to make a change or variation in the constitution, or is it because the other exercise is in respect of a legislation you are making the difference, or there is any other constitutional apart from the words used in Article 368?
Yes, I'm grateful. The reason for my making this distinction is that in the case of a law being passed, as the procedure prescribed in 196 to 200, Article 196 to 200,
Yes.
even in these articles, your lordship will not find the word act. The bill is passed, goes to the governor or the president and assented. But in Article 123 and 213, which is ordinance making power, there is special mention that once the ordinance is passed, within 6 months, it must be placed before the houses and converted into an act. So therefore, there the position is that the legislative amendment, once it is passed, it itself becomes a statutory provision and act. Here the Constitution stands amended in terms of bill.
Bill has to be introduced in the parliament to be passed.
The Amendment Act is an act by itself. It's another matter that in the publications we find that that is incorporated. And at the foot you'll also find that that is an Amendment Act inserted by this Amendment Act. But that amendment is a separate independent enactment which then inserts itself into the main enactment. Not a matter of great substance, but this is a distinct procedure there. There is no provision which says that the moment the bill is passed, the original act will stand amended in terms of the bill. So this is a very potent expression. Mr. Nariman, Wali Nariman employed this expression for getting the reference. And I am banking on that very expression for a different conclusion. What he wanted to say was that once the bill is passed, then it becomes incorporated. The earlier provision is gone forever. It will not return. That was his logic.
You are using Nariman's Gada for another purpose.
Yes. The Gada is there in 368. But we are swinging it in different directions, one on the right, one on the left.
But on the third situation, of course, is the second was legislative
And the
incompetence.
third is where the
Violative
law
of fundamental
is
rights.
breaching the fundamental rights or some other constitutional limitation, like in Article 286.
Now, 13.2 says that any law which is in breach of Part 3 is void. So how is that voidness distinguished from a law which is void on the ground that, or an act which is void on the ground that it is in breach of the basic structure?
So on 13, there is some divergence in the judgments of this court. Initially from case.
Constitutional amendment,
Only to a law.
even it's three.
So constitutional, this Keshav Madhav Menon, Peshikaka, and Sundararamayar. Sundararamayar was dealing with breach of Article 286. So the cases from Keshav Madhav Menon up to Peshikaka, they were dealing with Article 13(1), which is existing law, which continues by virtue of Article 372. And since it was a law made before the advent of the Constitution, it will never be void from inception. So it becomes void with effect from the date when the Constitution was made and to the extent of inconsistency. Article 13 in both 13(1) and 13(2) says to the extent of inconsistency, which will always be the case. So the doctrine of eclipse, etc., came into play.
Yes.
Now, in that respect, there is no difference between 13(1) and 13(2). Both say to
Void.
the extent of inconsistency, void. But because of the very nature of 13(1), the laws which are being considered being of the past, therefore, it is said that the law remains on the statute book. It is good for the past. Second, if the breach is of Article 19, now that's another feature, that these cases are dealing with cases of breach of Article 19, which is limited to citizens. That's a right conferred exclusively on citizens, not on non-citizens. And companies are not citizens, as the law stands. There is some debate on that because of the wide range of activities which the companies today are regulating and operating on. But keeping that aside, the 19 is limited to citizens. So the debate was that even if the law has been declared void on the ground of 19(1)(f), that was Balsara. And that's how it was Peshikaka emerged, to find out what is the effect of the declaration. So it is said that even if, though it is non-existent, ineffective, unenforceable with respect to citizens, because their rights have been affected and found to be and declared to be void. But with regard to non-citizens, it survives and remains on the statute book, therefore. So these observations which the petitioners want to deploy, Lords, are completely in a different context, where fundamental right under Article 19, which is limited to citizens, is impacted. And consequently, a distinction between citizen and non-citizen surviving qua non-citizen. And this is where Ambika Mill's case said that if in such a situation, the laws covered by 13(1) would survive with non-citizens, it would equally survive with the citizens, with the non-citizens in case of 13(2).
Sorry?
If the law survives on the statute book, where non-citizens, in the case of Article 13(1), the same would be the position with regard to Article 13(2).
It doesn't make a difference.
That is what Justice Matthews says, that even with regard to 13(2), if there is a breach of Article 19, which is limited to citizens, so there can't be a different result. So that is a debate, my lord, which is centering on this citizen, non-citizen difference, which is limited to Article 19. Yesterday, my lord, the Chief Justice asked me about what would be the position if there is a breach of Article 14, 20, 21. Now, they are not limited to citizen. This differentiation and this consequence over which there is a debate would not be there in case of breach of 14 and 19.
There's a breach of 14 or 21.
It would be word ab initio, that the result is same. Because fundamental rights are also imposing an incapacity on the legislature in a different way. My fundamental right is a restriction, a limitation on the competence, unless they justify as a reasonable restriction in the various heads, or otherwise on the various parameters which have been declared by lordships, qua Article 14 or 21. There are certain, none of the fundamental rights are absolute. So there are certain criteria to judge the law. That test has to be passed. And today they don't stand in independent silos. Therefore, each of wherever the impact is, wherever the effect falls, that fundamental right, that test has to be.
Therefore, in other words, according to your submission, a law which is in breach of Articles 14 and 21 would suffer from the same consequence as a constitutional amendment,
Yes.
which is in breach of the constituent or which is in breach of the doctrine of constituent competence.
Yes.
That is, it either vitiates the procedure which is spelled out in 368, or alternately, it violates the basic structure.
So I would bring it at par with legislative incompetence, because we are dealing with the legislative law. The constituent power stands on its own. It's a standalone provision, Article 368, which will be judged on the anvil of 368, what is the effect. But legislative incompetence arises on two aspects. One is that you have to have the subject matter in your field. And the second is that you should be on the right side of the various provisions of the Constitution. What you cannot do under the Constitution, any provision of the Constitution, beyond you. So the resultant is same. The only debate arises under 19 because of citizen, non-citizen, which in my respectful submission, Milord, once the court is declaring a provision under 13(2) as void, then it is up to the court, unless the court says that we are making this declaration and limiting it to the citizens alone. The declaration of voidness will have full play. This aspect has not been considered in Sundara Ramayar. And Mahendra Lal Jaini's case is right.
Have you captured this part of your submissions in your note?
Yes.
Mr. Trivedi?
I have Milord.
Just also like to read along a
Yes.
little bit.
So when Ambika Mill says that even in the case of 13(2), the law would survive with non-citizens, that would be a matter for the court's declaration. That's my humble submission. When the court is declaring the law as void, being in breach of 13(2), it's for the court to declare. For there may be so many laws which may not be applicable to non-citizens, may be applicable only to citizens. Then why should that consequence
So it is for the court to either save
Yes.
all the consequences of the declaration of voidness or give it untrammeled effect,
Trammeled effect?
which the court will say everything goes.
Yes.
The court may say, well, we'll do it prospectively, or that we will save transactions which have taken place under the law.
Or defer.
That it has a variety of options open.
It's a variety of options. The power of declaration, doctrine of ultra vires gives wide power.
So if third-party rights have taken place under the law, say people have been regularized under a law which is found to be void, may say that it will not affect the consequences which have already emerged, so that we don't want to displace the creation of third-party rights or third-party entitlements which have ensued under the law.
So if the declaration is absolutely wide, then it would not lie in the mouth of any authority or any person to say that we will read the whole judgment and see that it was challenge was made by a citizen and the fundamental right was.
Question which arose before the 7-judge bench in the ordinances case. What happens when an ordinance
Yes.
is either held to lapse or an ordinance is held to be a fraud on power? What happens to the consequences which took place when the ordinance was in operation? One view was that, well, those consequences survive because they were made by a constitutional authority which had the power to make that ordinance.
Yes.
So we applied the test of public interest.
Yes.
Justice Gajendra took a very clear view in the sense that he said everything which was done would survive. So we took a more nuanced view in Krishna Kumar Singh and said it depends upon how the court perceives it. You may apply the test of public interest and save consequences even under an ordinance which has otherwise been held to be void or to have lapsed.
The
That
lordships,
of course,
Yes.
your lordships went to the extent of saying that the ordinance making power does not contemplate creation of a permanent state of affairs. Because the ordinance has to be placed before the House, then the House can disapprove it, and then the executive can never say, I have created a permanent state of affairs. To hell with it, whether you have passed it or not passed it, or approved or disapproved. So parliamentary democracy demands that will prevails.
Because it is an exception to the lawmaking power of the legislature
Yes.
or the parliament.
Yes.
So there can't be an ordinance, Raj.
Yes. My Lord, the Chief Justice rendered the judgment in that Krishna Kumar Singh's case. So it is better to leave it to the court, and not to the authorities, and then later on to say that even though you have
your
declared it void.
submission then in summation is this, that what following the declaration of section 4 being null and void in para 75 of Minerva Mills,
Yes.
it is as if that the bill which proposed to amend the constitution was stillborn. It was never
contained
attained.
section 4.
It never attained the status of a bill which was validly passed,
Yes.
and therefore, once that is effaced, the original provision of Article 331C was never, in that sense, substituted. The substitution never took effect,
Yes.
according to you.
So doctrine of basic structure goes to the very first step, introduction of the bill. They don't have any power to introduce a bill which amends, seeks to destroy the basic feature.
But who is to say that?
Court will say this.
Later.
Later, your lordships have said in Keshwanan that on a case-to-case basis, your lordship will decide.
Point now. Would you like to just show us, as my learned brother, Rishikesh Roy was asking, the note which you would like to just read out that, how you have formulated it?
Which volume and which? Volume 2N, my lord, deals with this part. If I may just draw my lord's attention before reading, my lord, to one more aspect of it, that 368 says that in terms that you may amend by addition, variation, or repeal. Even if these words were not there, the word amend will include all these forms. But they did not leave it for implication expressly mentioned. Now, this is an additional alternative submission that in this case, we have to look at the nature of Section 4. As my Lord the Chief Justice said, that it's a case of expansion, enlargement. So the intent was not to, the intention of the Parliament in introducing 42nd Amendment Bill was not to simply sit or repeal 31's unamended 31C. The intention was to add, to bring in some more directive principles for the entirety of Part 4, in addition to 39B and C. So Section 4 is a substitution by addition. It will not be a case of variation, because variation would mean putting 39B and C in some different way. If the same thing is to be put in a different way, then that would be variation. But if A plus B, then it is to be C plus D and E are also to be brought in. That's a case of addition. So the result of declaration would be that the addition goes. And this aspect, Lord, has been brought out in the case of tobacco, what's international tobacco, Indian tobacco. That is volume 5A, page 3218. to 17 at page 3223,
Way.
volume 5A, page 3218, and the relevant portion is at page 3223. It's a case of repeal of repealing act. In the context of a tax on sale of cigarettes,
3233.
3223.
3223.
Para 14 to 17. Yeah, please.
Yes.
The ratio of the two separate but concurring judgments of the appellate bench of the High Court is that the 1954 Act had the effect of completely repealing the 1941 Act in relation to cigarettes, and the repeal of 1954 Act in relation to cigarettes by the 1958 Act did not revive the operation of 1941 Act in regard to cigarettes on the principle that the repeal of repealing Act does not revive the repealed Act. Since the 1941 Act stood completely obliterated from the statute book in relation to cigarettes, no sales tax would be payable in regard thereto, either under the 1954 Act or under the 1941 Act. Upon these premises, it was held that the company as a dealer in cigarettes and smoking mixture is not entitled to any certificate of registration under the Act of 1941, as it is neither a dealer within the meaning of that Act nor liable to pay tax. The general rule of construction is that the repeal of a repealing Act does not revive anything repealed thereby, but the operation of this rule is not absolute. It is subject to the appearance of a different intention in the repealing Act. Again, such intention may be explicit or implicit. The questions, therefore, that arise for determination are whether in relation to cigarettes, the 1941 Act was repealed by the 1954 Act and the latter by the 1958 Act, whether the 1954 Act and the 58 Act were repealing enactments, whether there is anything in the 1954 Act and the 1958 Act indicating a revival of the 1941 Act in relation to cigarettes. It is now well settled that repeal connotes abrogation or obliteration of one statute by another from the statute book as completely as if it had never been passed. When an act is repealed, it must be considered except as to transactions passed and closed as if it had never existed. Repeal is not a matter of mere form, but one of substance, depending upon the intention of the legislature. If the intention indicated expressly or by necessary implication in the subsequent statute was to abrogate or wipe off the former enactment, wholly or in part, then it would be a case of total pro tanto repeal. If the intention was merely to modify the former enactment by engrafting an exception or granting an exemption or by super adding conditions or by restricting, intercepting or suspending its operation, such modification would not amount to a repeal. Broadly speaking, the principal object of repealing is to excise dead matter full of superfluities. So what I rely upon is this, that please look at the intent of the assembly when they were introducing section 4. What was the intention?
So for instance, to take your line of argument further, when they substituted the words, the principles contained in Articles 39B or C, they said all or any principles in Part 4. What Parliament was intending really was to do this, according to you. Suppose they had said, instead of 39B and C, they had said 38, 39, 39A, 40, they produced all the provisions of the directive principles, right? Including 39B and C. And that was invalidated by Minerva Mills. 39B and C would still stand. Because, that had been upheld in Keshwanand. So instead of physically enumerating all the provisions of the directive principles, namely 38 to 51. What they did was they said all or any of the principles in part 4. So does that make much of a difference? If they had done the former, obviously it couldn't have been argued that, the entirety went, because they would have struck down everything but 39B and C. So the fact that instead of physically enumerating all the articles in the directive principles, Parliament used a catch-all phrase, all or any principle, should really not make any difference according to your submission.
So
Because that was the intent. The intent was to expand.
Yes. And that intention cannot be ignored. That's the primary thing, very important aspect.
A substitution, in a sense, also involves some degree of repeal. Because when in exercise of the constituent power or the legislative power, the legislature is substituting a provision, it is also implicitly repealing a provision. Because you are substituting in the sense you are repealing the earlier provision and bringing a new provision in it.
So it's, as I said, my lord, once we bring in the intention, we have to see there are substitutions and substitutions. There can be a substitution by addition, substitution which is intended to vary, substitution which is intended to repeal.
A substitution may be of a completely new provision.
Completely new provision.
You want to completely obliterate an erstwhile provision.
Yes.
And bring in a new provision which doesn't even deal with the same subject matter.
So the amendment bill could have said that such Article 32C is repealed. And then would have said that we are inserting something else in its place. Instead of splitting up this substitution, dehorse the context of Section 4 and saying that it involves two steps, split it up. One is erasure and other is insertion. And therefore it is subsumed. Now this theory of split up and subsuming militates with the context of Section 4. The purpose, the intent of Section 4, quite apart from the fact that in terms under 368, it will mean that it never happened. So even if we treat it that it became part, the only thing which goes out is what was added.
Now, what is the next? Anything else now remains in your submission?
Now, there was one in this context, there was a reference to an earlier exercise which Parliament, it is said, wanted to reduce. But Rajya Sabha,
they wanted to bring it in conformity with Keshwanand, but the bill never passed the Rajya Sabha.
Never passed. So in the first case, when they inserted 32C expanded, so they were emboldened by Keshwanand Bharati that it has upheld 39B and C, so we can now have the whole of it. So completely shut out, avoid the courts completely, no scrutiny.
Then they wanted to bring the amended 31C back to the pre-amended.
But the Rajya Sabha said, no, why reduce the powers which we have gained? But that is all prior to the declaration by the court.
And ultimately, that will not affect.
That is only irrelevant.
The legislature wanted to do. There may be a variety of reasons why a bill lapses. Maybe the Parliament, of course, this was the Rajya Sabha, but in a given case, the term of that legislature, the lower house may come to an end. The government of the day may not have the majority in the Rajya Sabha in the case of the Rajya Sabha, but that shouldn't affect how we construe the provision. We'll have to construe it independently.
They could have a thought also.
Isn't it, Joshi? And
It's another matter that had they accepted that amendment, perhaps it would not have been necessary for the court to go into it. Because it's reduced. They would have only just examined nothing because Keshwanand Bharati has already upheld 30, unamended 30. So there was nothing. So of course they did not want to give up, and your lordships made them give it up. In Minerva Mill, when your lordship struck it down. So what they did not do it, the court did it. Now kindly have just three cases only on that point which I am building up. That is Sundara Ramayar. all these cases have expressly said that if it is incompetent legislatively, it's of no effect. And in fairness, the petitioners did not say that in a case of legislative incompetence, it will still remain on the statute book. An incompetence case, never bring it on the statute book at all. Volume.
Page.
At page 421. So this was a case. So if your lordship accepts my first two submissions which I have made, then Lord, it may not be necessary to go into this debate about 13.1, 13.2, etc. It doesn't arise directly in our case. But since it has been raised and made, the principles have been tried to be lifted up and utilized.
By them.
Yes.
After a provision is struck down by the Constitutional Court, any provision of the Constitution or maybe some act also, that attains finality. Is there automatic change in the act also? Because this is never made. You have seen the Keshwananda also. We have seen your L. Chandra Kumar. There are a lot of, now you don't see those changes in the Constitution. They are bound to do it or not? Or is it automatic?
Revival.
Not revival. Provision is struck down. Whether the Constitution is deemed to be amended to
In
that,
my respectful submission, the statute stands corrected as it is, once your lordship declares.
it has to be.
Then
Shall be deemed to be
I'm not
deleted.
aware of a single act which this court has declared or any high court has declared ultra virus where the legislature has proceeded to pass an act to remove it from the state.
Yes, we have not seen that.
So subject to my lord, correction from my learned.
We have also not seen that. These are still there. in the
Never done, my
Constitution.
lords. And I'm grateful for this question, Lord. The parliament has never passed, the legislatures, no state legislature has ever passed. They abide by the dictum of the court, and that's because of the mandate of the Constitution flowing from Article 136, 141, 142, and more importantly, 144, which specifically says that all civil or authorities will have to
Abide by.
act in aid, very strong word, act in aid of the Supreme Court.
That doesn't create an anomalous situation. Somebody sees,
So there's no anomaly at all. So Parliament never does it in India. We don't need to go abroad, cross the 7 seas, and find out what America is doing or what UK is doing, what they feel like.
Parliament had not been doing, whether it should be done or not.
And they have also not created any Taj Mahal where all these dead acts can be placed as a mausoleum. So it goes, it's gone.
No, only when an amending act, after the amendment is made and it comes to the statute, then the amending act is repealed.
Amending act.
Amending act is repealed. That is all become dead wood.
That is the kind of.
That exercise the legislature does.
Once they incorporate it.
Yes.
But that's a meaningless. But once the court declares void,
That's a judicial verdict,
not
unless
subject
they
to
remove the
correction.
basis of the judgment
Your
and
worship is right.
pass another validation.
No, but they do it. They do it. That's to remove the clutter.
Yes.
That is only removing the clutter, my lords. That is not a dead wood. Since it has been incorporated, therefore. But the dead wood which is resulting from the declaration of the court, I have not come across, Lord, subject to correction, Lord, if there is. And that is of no effect. One more aspect.
It gets effaced from the constitution or from the statute.
It's not simply unenforceable. No.
Actually.
There was one other, Lord, I'm grateful for the question. There was one other aspect which the petitioners presented, and that was that since after declaration of voidness, it remains on the statutory parchment, and it's not a case of repeal. The court cannot repeal it. Only Parliament can repeal it. And therefore, there can't be two provisions on the statute book side by side. Now, this may sound attractive, Lord, but what really is happening is there will never be a case of two provisions on the statute book. One is alive, the other is dead. And in our society, Lord, where being and becoming is a process which continuously goes on, people getting born, people dying. So the living and the dead are part of this world. So every living organism, which the Constitution is. So therefore, this is nothing strange, Lord, that there is a provision. I'm assuming the worst case scenario that something is remaining there unenforced. So there is nothing militating. There is no inherent contradiction between a revived, alive provision and a provision which is dead, having been declared by the court of law to be so.
That only.
We have cemeteries, Lord, so it can lie there dead. No problem. We have to look at what is operating. Sorry, boss.
There is one more question on that. Now, it is at the option or free will of the publisher only what to publish in the book. Or some provision is struck down.
I'm sorry, Murali.
Any provision is struck down by the Supreme Court, finally,
Yes.
right? One is that 144 says everybody will come in aid. So whether in that context, the Parliament or the state or the Parliament in Constitution or the central statutes or the state statutes don't follow that mandate by amending the act, because they are to come in aid, number one. Number two, it's the free will of you see this Constitution, you must have a copy of it.
Yes, my friend.
Article 323A, 2D, struck down by this court. Chandra Kumar. 323 VVPA2D. This is at page 310.
323B.
2D. Judicial review.
Exclude the jurisdiction of all courts except the jurisdiction of the Supreme Court under Article 136.
This was struck down in Alchandra Kumar.
Yes.
This book doesn't mention it.
So these are the publications.
This is what I'm asking. It is at the free will of the publisher only. No, how the layman will come to know? He will not search the law for
The
anything.
publisher should not include what is struck down.
Any note, anything, no, nothing is there. 323B,
The
3D also same.
the note is below, after the entire provision at page 313, if your lordship. That's correct.
Book.
Layman, but then we'll be out of business.
Mr. Shankaran, but one thing to your credit, if you see a little bit of what's happening in this time of the year, I've noticed that your book of the Constitution, your means the one which is edited by you,
At the end
is
of the.
bandied around quite a bit of late. So you might take credit for it.
At the end of the section. I mean,
Others
it's
also
the end-
mentioned about.
At the end of the provision.
My friend has presented to all of us.
Publication also, nothing is
There's
mentioned.
nothing. Under 144, they should have complied.
Published by the Government of India in
So
2015.
these are executive exercise of publications.
This
but
is, the
they
question
should
is that
do.
only. If 144 is there, why don't they come in aid and give effect to the judgment?
Yes, they
It is
should.
giving effect to the
At
judgment.
least they should mention somewhere boldly that it
Why
doesn't
can't they-
survive.
Why can't they make the act only of constitution corrected as declared by this?
They should do it. So, right.
Will it come in the legislation, directing a legislation?
In the universal publication word, in the footnote, they have mentioned,
Yes, in some books it is there, some books it is.
some it doesn't.
End
But
of the-
what they should be doing is that they should eliminate it from there.
Yes,
And in the footnote, they should provide that this was the provision which has been struck down.
it should be based on this.
So that one reads it.
This is the automatic act.
And in order to protect their skin, if they are to be questioned, that so-and-so council had suggested that this is how it should be done.
Kindly have this verse.
At some point of time.
With Article 286.
286.
So they said that the Act 286 doesn't say that a law which contravenes 286 is void. So he says the law was valid as to a part which was enforceable. Then that cloud was lifted, and therefore it became valid in its entirety once the bar under 286
So it
was lifted.
United Motors upheld the provision. Bengal immunity then took a
They
different
distinguished
view.
Pesikaka and Dhakras
All are
on the ground that
discussed.
they dealt with Article 13.
Yes.
Actually, there are three extracts there which are important: 421, 427, 428, and 429.
Absolutely right. That 421.
Just it.
My. May I just,
At 421,
may I place it?
yes.
Now, in considering the question as to the effect of unconstitutionality of a statute, it is necessary to remember that unconstitutionality might arise either because the law is in respect of a matter not within the competence of the legislature, or because the matter itself being within its competence, its provisions offend some constitutional restriction. In a federal constitution where legislative powers are distributed between different bodies, the competence of the legislature to enact a particular law must depend upon whether the topic of that legislation has been assigned by the Constitution to that legislature. Thus, a law of the state on an entry in List 1, Schedule 7 of the Constitution would be wholly incompetent and void. But the law may be on a topic within its competence, as for example, an entry in List 2, but it might infringe restrictions imposed by the Constitution on the character of the law to be passed, as for example, limitations enacted in Part 3 of the Constitution. Here also the law to the extent of the repugnancy will be void. Thus, a legislation on a topic not within the competence of the legislature and a legislation within its competence but violation of constitutional limitations have both the same reckoning in court of law. They are both of them unenforceable. But does it follow from this that both the laws are of the same quality and character and stand on the same footing for all purposes? This question has been the subject of consideration in numerous decisions in the American courts, and the preponderance of authority is in favor of the view that while a law on a matter not within the competence of the legislature is a nullity, a law on the topic within its competence but repugnant to the constitutional prohibitions is only unenforceable. This distinction has a material bearing on the present discussion. If a law is on a field not within the domain of legislature, it is absolutely null and void. And a subsequent cession of that field to the legislature will not have the effect of breathing life into what was a stillborn piece of legislation, and a fresh legislation on the subject would be. So even subsequent conferment is unhelpful. But if the law is in respect of a matter assigned to the legislature, but its provisions disregard constitutional prohibitions, though the law would be unenforceable by reason of those prohibitions, then once they are removed, the law will become effective without reenactment. Then leaving the rest, if your lordship has.
Now you can go to 427, actually, the bottom of 427.
Peshikaka and all are dealt with in page 424.
And on the discussion at 427 after dealing with Peshikaka and
427 bottom.
Yeah, the result.
The result of the authorities may thus be summed up, where an enactment is unconstitutional in part but valid as to the rest, assuming of course that the two portions are severable. It cannot be held to have been wiped out of the statute book, as it admittedly must remain there for the purpose of enforcement of the valid portion thereof. And being on the statute book, even that portion which is unenforceable on the ground that it is unconstitutional will operate proprio vigere when the constitutional bar is removed. Please mark this. It's not a general statement. In this case, what happened was that Parliament had imposed a restriction. Under 286, Parliament specifies, supposing that special goods of importance, 4% will be the tax. Now the state legislature makes some law and had said that as and when the limitation is removed, it will be something different. Now once the Parliament removes, it starts operating automatically. That was the position here.
Then you can see the bottom of page 428, that will be important because
the fact that it is invalid.
The bottom of 428, the last paragraph. Oh, you are on 428, right?
Yes.
That before you read the last para, about 10 lines from the continuing para, the result, yes, the fact that, yes.
The fact that it is invalid as to a part has not the effect of obliterating it out of the statute book, because it is valid as to the part and has to remain in the statute book for being enforced as to that part. The result of the enactment of the impugned act is to lift the ban under Article 286(2), and the consequence of it is that the portion of the explanation which relates to sales in which property passes outside Madras, but the goods are delivered inside Madras, and which was unenforceable before, became valid and enforceable. In this view, we do not feel called upon to express any opinion as to whether it would make any difference in the result if the impugned provision was unconstitutional in its entirety. This is very important. So even 286.
And now last para there, 428, that then sums it up.
There is one other aspect of the question to which reference must be made. The decisions in Peshikaka and Bhikaji Dhakras both turn on construction of Article 13, which enacts that law shall be void to the extent they are repugnant to the provisions of Part 3. We are concerned in these petitions not with infringement of any of the provisions of Part 3, but of Article 286(2), and the point for our decision is as to the effect of the infringement of that provision. Article 286(2) does not provide that a law which contravenes it is void, and when regard is to be had to the context of that provision, it is difficult to draw the inference that.
And now you can just see the last sentence of that para, whether we consider the question on broad principle
as to the effect of unconstitutionality of a statute or on the language of Article 286(2). the conclusion is inescapable that Section 22 of the Madras Act and the corresponding provisions in other statutes cannot be held to be null and void and non-est by reason of their being repugnant to 286(2) and the bar under that article having now been removed. So the substance.
The argument was that now that the bar was removed, Parliament has enact a fresh law. This was not necessary, they said, to enact a fresh law. The bar was removed and therefore they could.
Therefore, it starts operating. But they took caution that if in some case it is entirely, then it doesn't matter really whether the provision calls it void or not. If a constitutional prohibition anywhere residing.
So really speaking, your argument places the violation of the basic structure on the same pedestal as a law which is lacking in legislative competence. So that it is then never, it's null and void.
Null and void.
And it is never deemed to have entered the statute book at all.
Absolute nullity. Now this was again considered because in Deep Chand, annexure 22 of volume, this is not in that big compilation. It's in volume 2. Volume 2, N,
Page?
at page 1027.
What is the judgment?
Deep Chand.
Deep Chand.
Yes. All constitution benches.
54, yeah.
At page 1036. And here para 14 and 15, 1036. It is therefore manifest that in the construction of the constitutional provisions dealing with the powers of the legislature, a distinction cannot be made between an affirmative provision and a negative provision. For both are limitations on the power. The Constitution affirmatively confers a power on the legislature to make laws within the ambit of the relevant entries in the list and negatively prohibits it from making laws infringing the fundamental rights. It goes further and makes the legislative power subject to the prohibition under Article 13(2). Apparent wide power is therefore reduced to the extent of the prohibition. If Article 245 and 13(2) define the ambit of the power to legislate, what is the effect of a law made in excess of that power? The American law gives a direct and definite answer to this question, fully in its constitutional limitations under the heading consequence if statute is void. Skip this one, Willis and Willoughby and all are quoted. Section para 18. Then they consider right from Keshav Madhav Menon, all cases. Para 18 at page 1039. We shall now proceed to consider the decisions of the court to ascertain whether the said principles are accepted or departed from. That's the American principles. First is Keshav Madhav Menon is there, and then para 20 is Peshikaka. Sagir Ahmed, and then para 25 if your lordship has. at page 1048. Please come to page 1049 towards the middle. The result. Sentence beginning, the result of the aforesaid discussion may be summarized in the following propositions. One, whether the Constitution, Lordship got this portion? The result of the aforesaid discussion may be summarized in the following propositions. One, whether the Constitution affirmatively confers power on the legislature to make laws subject-wise or negatively prohibits it from infringing any fundamental right. They represent only two aspects of want of legislative power. The Constitution in express terms makes the power of legislature to make laws in regard to entries in the list of 7 schedules subject to the other provisions of the Constitution, thereby circumscribes or reduces the said power by the limitations laid down in Part 3 of the Constitution. It follows from the premises that a law made in derogation or in excess of that power would be ab initio void wholly, or to the extent of the contravention as the case may be. 4. The doctrine of eclipse can be invoked only in the case of law valid when made, but a shadow is cast on it by supervening constitutional inconsistency or supervening existing statutory inconsistency. When the shadow is removed, the impugned act is freed from all blemish or infirmity. Applying the aforesaid principles to the present case, we hold that the validity of the act could not be tested on the basis of the Constitution, but only on the terms of the relevant articles as they existed prior to the amendment. Kindly have Mahinder Jaini's case, which is volume 5. I'm sorry, it is the same volume at page 157. Para 21 at page 172. We may in this connection also refer to the difference in the language and scope of Article 31 and 13.2. Article 13.1 clearly recognizes the existence of pre-existing laws in force in the territory of India immediately before the commencement of the Constitution, and then lays down that in so far as they are inconsistent with the provisions of Part 3, they shall be void to the extent of such inconsistency. The pre-Constitution laws, which were perfectly valid when they were passed, and the existence of which is recognized in the opening words of Article 13.1, revive the removal of the constituency in question. This effect is doctrine of eclipse, if we may say so with respect, was applied in Bhikaji Narayan case. Article 13.2, on the other hand, begins with an injunction to the state not to make a law which takes away or abridges the rights conferred Part 3. There is thus a constitutional prohibition to the state against making laws taking away or abridging fundamental rights. The legislative power of Parliament and the legislatures of the state under Article 245 is subject to the other provisions of the Constitution, and therefore subject to Article 13.2, which specifically prohibits the state from making any law taking away or abridging the fundamental rights. Therefore, it seems to us that the prohibition contained in Article 32 makes the state as much incompetent to make a law taking away or abridging the fundamental rights as it would be where law is made against the distribution of powers contained in the 7th schedule to the Constitution between Parliament and the legislature of a state. Further, Article 13.2 provides that the law shall be void to the extent of the contravention. Now, contravention in the context takes place only once when the law is made. But the contravention is of the prohibition to make any law which takes away or abridges the fundamental right. There is no question of contravention of Article 13(2) being a continuing matter. Therefore, where there is a question of a post-constitutional law, there is a prohibition against the state from taking away or abridging fundamental rights. And there is a further provision that if the prohibition is contravened, the law shall be void to the extent of the contravention. In view of this clear provision, it must be held that unlike a law covered by 13(1), which was valid when made, the law made in contravention of the prohibition contained in Article 13(2) is a stillborn law, either wholly or partially depending upon the extent of contravention. Such a law is dead from the beginning, and there can be no question of its revival under the doctrine of eclipse. A plain reading, therefore, of the words in Article 13(1) and 13(2) brings out a clear distinction between the two. 13(1) declares such a pre-constitutional law as are inconsistent with fundamental rights. 13(2) consists of two parts. The first part imposes an inhibition on the power of state to make a law, contravening fundamental rights. Second part, which is merely a consequential one, mentions the effect of the breach. Now, what the doctrine of eclipse can revive is the operation of a law which was operative until the Constitution came into force and had since then become inoperative either wholly or partially. It cannot confer power on the state to enact a law in breach of Article 13(2), which would be the effect of the application of the doctrine of eclipse to post-constitutional law. Therefore, in the case of 13(1), which applies to existing law, doctrine of eclipse is applicable as laid down in Bhikaji Narayan. But in case of a law made after the Constitution came into force, it is Article 13(2) which applies, and effect of that is what we have already indicated, and which was indicated by this court as back as Sagir Ahmad. Then they go on to explain that Sir Keshava Madhavna, etc. And the last the next case was the Sambika Mills, which they rely. But in my note at page 10, I'll mention that later on. I'll complete afterwards.
Mills, volume?
Same volume, annexure 8, page 202.
202.
Para 32. It refers to Sundara Ramaiah, Deepchand, etc., but it's necessary to read it to show how now Ambika Mills is trying to move slightly away from. In Sundara Ramaiah, Justice Venkatrama Iyer said that a law made without legislative competence and law violative of constitutional limitations on legislative power were both unconstitutional and both had the same reckoning in a court of law, and they were both unenforceable. But it did not follow from this that both laws were of the same quality and character and stood on the same footing. Proposition laid down by the learned judge was that if a law is enacted by the legislature on a topic not within its competence, the law was a nullity. But if the law was on topic within its competence, but it violated some constitutional prohibition, the law was only unenforceable and not nullity. In other words, law, if it lacks legislative competence, was absolutely null and void, and a subsequent session of the legislative topic would not revive the law which was stillborn, and the law would have to be reenacted. But a law within the legislative competence but violative of constitutional limitation was unenforceable, but once a limitation was removed, law became effective. The learned judge said that the observations of Justice Mahajan in Peshikakal's case, that quae citizens, that part of section 13B of the Bombay Prohibition Act which had been declared invalid by this court had to be regarded as null and void, could not in the context be construed as implying that the impugned law must be regarded as non-est so as to be incapable of taking effect when the bar was removed. He summed up the result of the authorities as follows: where an enactment is unconstitutional in part but valid as to the rest, assuming of course that two portions are severable, it cannot be held to have been wiped out of the statute book. It admittedly must remain there for the purpose of enforcing the valid portion thereof, and being on the statute book, in that portion which is unenforceable on the ground that it is unconstitutional, will operate proprio vigere when the constitutional bar is removed. In Deepchand, it was held that a post-constitutional law is void from its inception, but that pre-constitutional law, having been validly enacted, would continue in force so far as non-citizens are concerned after the constitution came into force. The court further said that there is no distinction in the meaning of the word void in Article 13.1 and 13.2, and that it connoted the same concept, but since from its inception the post-constitutional law is void, the law cannot be resuscitated without reenactment. Justice Subbarao, who wrote the majority judgment, said after citing the observations of Justice Das, Acting Chief Justice, in Keshav Madhav Menon, the second part of the observation directly applies only to a case covered by 13.1. For the learned judges say that the laws exist for the purpose of pre-constitutional rights and liabilities. They remain operative even after constitution as against non-citizens. The said observation could not obviously apply to post-constitutional laws. Even so, it is said that by parity of reasoning, the post-constitutional laws are also void to the extent of repugnancy, and therefore the law in respect of non-citizens will be on the statute book, and by the application of doctrine of eclipse, the same result would flow in its case also. There is some plausibility in this argument, but it ignores one vital principle: the existence of or the non-existence of legislative power or competency at the time when the law is made governs the situation. Chief Justice Das dissented. He was of the view that post-constitutional law may infringe either a fundamental right conferred on citizens or a fundamental right conferred on any person, citizen, non-citizen, and that in the first case, the law will not stand in the way of exercise by the citizens of that fundamental right, and therefore will not have any operation in the right of citizens, but it will be quite effective as regards non-citizens. Then they discuss Jaini's case. Kindly come to para 36. If the meaning of the word void in Article 13.1 is same as its meaning in 13.2, it is difficult to understand why a pre-constitutional law which takes away or abridges the rights under Article 19 should remain operative even after the Constitution came into force as regards non-citizens, and a post-constitutional law which takes away or abridges them should not be operative as respects non-citizens. The fact that pre-constitutional law was valid when enacted can afford no reason why it should remain operative as it respects non-citizens after the Constitution came into force, as it became void on account of its inconsistency with provisions of Part 3. Therefore, the real reason why it remains operative as against non-citizen is that it is void only to the extent of its inconsistency with the rights conferred under Article 19, and that its voidness is therefore confined to citizens. Ex hypothesi, the law became inconsistent with their fundamental rights alone. If that be so, we see no reason why a post-constitutional law which takes away or abridges the rights conferred by Article 19 should not be operative in regard to non-citizens, as it is void only to the extent of the contravention of the rights conferred on citizens, namely those under Article 19. So this is the divergence which emerges, but only in the context of Article 19, because Article 19 is limited to citizens. Other fundamental rights are not so limited. If, however, the court finds that any other fundamental right is limited, but this is we find there are two constitution benches of equal strength. So this obviously cannot amount to overruling of the earlier dictum in Deep Chand and Jaini, but there is a divergence. All three of them being constitution benches of same strength. Now this was sought to be supported.
Can you formulate the divergence that Ambika
The
Mills?
divergence between Ambika Mills on the one hand and Mahendra Lal Jaini and Deep Chand is that both are dealing with a situation in 19, unlike Sundara Ramaiah. But they are saying that one says that this proposition that a law which is violative of 13(1) continues to apply for the past transaction as well as for a non-citizen. Whereas this defect is noted by Justice Matthew in Ambika Mills that if this is the position with regard to the second aspect of non-citizens under 13(1), then the position will remain same under 13(2) also because Quay 19.
Quay 19.
Now, my learned friends want to enlarge this and apply it to 368. If it cannot apply, be translated and applied to legislative incompetence, it cannot be. So the soil is completely different. Before one applies a law declared in respect in one context, one has to note what were the limitations of Article 19, what is the structure of Article 19, what is the structure of other fundamental rights, and how it is different from incompetence cases. Incompetence means you don't have that power. Now to support this migration of the legal dictum in the field of 13(1) and applying it to 368, they sought assistance from the observations of the great jurist Shri H.M. Sirvai. Unfortunately, my learned friend quoted only proposition 4. Would have been more appropriate if entire para 8.30, which I have extracted at page 25 of my written note, to end. Page 25. So what Mr. Sirvai does is that he discusses first Keshav Madhav Menon, Peshikaka and Sundara Ramaiah cases, and then draws what are the propositions flowing from them, which is extracted in 8.30, para 27 of my note. The extract from Shri, I should have been Shri, H.M. Sirvai, Constitutional Law of India, 4th edition, volume 1, page 4156, is actually proposition 4 stated in para 8.30. This is reproduced. There is a distinction between a law unconstitutional for lack of legislative power and a law unconstitutional because of violative of provisions of the Constitution other than those which relate to the distribution of legislative power. A law which is unconstitutional for lack of legislative competence is void ab initio. A law which is unconstitutional for violation of constitutional limitation is unenforceable so long as it continues to violate constitutional limitation. Such a law, whether pre-constitution or post-constitution, is not wholly void if it violates fundamental rights. It is merely eclipsed by the fundamental right and remains, as it were, in a moribund condition as long as the shadow of the fundamental rights falls upon it. When that shadow is removed, the law begins to operate proprio vigere from the date of such removal unless it is retrospective. 3. A law void for lack of legislative competence is not revived if legislative power is subsequently given to the legislature which enacted it. A law partly void because of violation of constitutional limitation operates proprio vigere when limitations are removed. 4. When a court declares a law to be unconstitutional, that declaration does not repeal or amend the law. For to repeal or amend the law is a legislative and not a judicial function. This is what my learned friend wrote extracted in his written note. The word void in 13.1, 13.2 does not mean repealed, nor is the law declared void under 13.1 or 2 obliterated from statute book. Such a law is not wholly void, but by express terms of the article is void only to the extent of its repugnancy to or contravention of the provision of Part 3 relating to fundamental rights. The above conclusions were drawn by Shri Sirvai after discussing the cases of Keshav Madhav Menon, Peshi Kaka, Bhikaji Dhakras, and MP Sundara Ramaiah. Shri Sirvai proceeds to then consider the subsequent cases in Baseshwar Nath, Deep Chand, and Mahinder Lal Jaini and Ambika Mills. Based on the discussion, he called out the following propositions. That is 8.37. Justice Matthew. All this your lordships have seen, your lordship comes to see. In fact, I may read A also at page 27. If, as held in Mahendralal Jaini's case, the word void in Article 13.1.2 had the same meaning, it was difficult to understand why a pre-constitution law violating Article 19 should remain operative against non-citizens after the commencement of the Constitution, and a similar post-constitution law should not remain operative against non-citizens. The fact that the pre-constitutional law was valid when enacted was irrelevant in its continuing to operate against non-citizens, notwithstanding the provision of Article 13.1 of the Constitution came into force. The real reason why the law remained operative was that only the law became void under 13.1, which took away or abridged the fundamental rights under Part 3, and since Article 19.1 does not confer any fundamental rights on non-citizens, such a law remained operative against non-citizens. If so, a similar post-constitutional law would also remain operative against non-citizens. Rights do not exist in vacuum, they must inhere in some person, natural or juridical, and under Part 3, they inhere even in fluctuating bodies like religious denominations. See, the scheme underlying 13.1 and 13.2 is the same. Article 13.1 makes a pre-constitutional law to the extent of its inconsistency with fundamental rights. Article 13.2 makes a post-constitutional law void to the extent of its contravention of fundamental rights. In both cases, the law remains operative with non-citizens because Article 19 does not confer any fundamental rights on non-citizens. The voidness is not in them, but to the extent only of inconsistency or contravention. Therefore, void in Article 13.2 can only mean void as against persons whose fundamental rights are taken away or abridged by law. The law might be stillborn so far as the person, entities, or denominations, those fundamental rights are taken away or abridged, but there is no reason why this law should be void or stillborn as against those who have no such rights. So even according to the learned author, in part it is stillborn, which is a theory which your lordship will have to test in some case. In this case, doesn't require your lordships to go into all this. But since my learned friends have raised it, therefore only I am trying to demonstrate that these dictums and the debate is in the context of breach of Article 19 and in the context of a debate of citizen versus non-citizen.
Yeah.
So in some appropriate case, your lordships may go into all this, but in the present case, it's a case of incompetence, constituent incompetence, which may be considered to be akin to legislative incompetence, where all these cases, including the learned author, are at one, that in this case of incompetence, it is null and void, ab initio, beginning, as if it was not there at all, as if it had no effect. And in case of 368, it will be a case where the Constitution does not stand amended on account of Section 4.
Article 368(4) also was struck down because judicial review of the 42nd Amendment also was barred.
That's right.
That was also struck down
That's
in Minerva Mills.
yes.
Section 55.
Then they brought in Lord separation of powers. And it is well settled, Lord. I will not trouble your lordships. So page 30 and 31, I have mentioned 3 cases. Your lordships have said that under the Constitution of India, there is no rigid separation of powers. Even this court makes rules, rules of court, rules regarding to servants, etc. So there are some legislative functions. Then there is, as I said, the court makes judicially also makes law. Not in the way the Parliament does, but through interpretation and declarations. 141.
Most of the
So
rules.
overlapping of functions.
Yes,
Civil servants make most of the rules.
that's right. Most of the rules are made by them. So there's no rigid separation. Even in the matter of judiciary, notwithstanding that the fact that it is a basic feature of the Constitution, still the salaries are fixed by Parliament. There's so many things which Parliament does with regard to the courts and judiciary. The legislatures do. So,
Mr. Now.
so the separation of power doesn't really, the fact court doesn't need to repeal. So I will just draw your lordship, finally coming back, your lordship, just note at page 11, I go back, starting from Keshwanand, I go back to Keshavanand Bharti, and I place the 10 judges order which was finally passed in that case. I have extracted at page 11. And the direction number 2. Now kindly correlate this para 75, Chief Justice Y.V. Chandrachud uses the same expression, does not enable Parliament. So the ability of Parliament to introduce a bill is not there. The ability of Parliament to pass that bill is not there. Such a bill, therefore, itself, Section 4 being part of the bill, goes out. That ability is lacking. Now, this is something not there in 13.1, 13.2, so Lordship need not enter into that debate. And the next page I have quoted from the IR Polo's observation. The bold portions in 124 and 125. it would fall, last 4 lines of the bold portion in 125 would fall beyond the constituent power. And then at page 14 is para 75 of Minerva Mill, identical expression. Section 4 is beyond the amending power. Therefore void. So I'll just wind up now with giving to your lordships the 4 cases which I've listed out on the proper first part of it. On that first one, the first 2 cases are on material resources. That is 1992 Supplementary 1 SCC 692, Assam Selimanite. Volume 5, page 2640 at 2654.
654.
Yes, ma'am. And the second is Jilu Bhai versus State of Gujarat, 1995 Supplementary 1 SCC 596, Volume 5, page 2676 at page 2700, para 29. The first one is para 34. They have said that material resource has to be construed widely. The third case is Jagannath versus authorized officer, that's 1971 2 SCC 893. 893, para 18 and 29,
Volumes?
which is volume 2 annexure 7, volume 2N annexure 7,
Page?
at page 184, 198. This is with regard to acquisition, which I said, no, it's part of the 39B. So this case directly holds that acquisition and distribution go together under 39B. And the last is, Lord, Pathuma's case 1978 2 SCC 1. Para 5 and 8, volume 2N, annexure 18. That's page 891 at 898 to 900. This is a case of that agricultural credit loans, agricultural debt, which was wiped out and upheld by a 7 judges bench of this court. So even that is a material resource upheld with reference to 39B. Yes,
Yes.
the Landed Solicitor General has mentioned this case. I'm grateful.
Thank you, Mr. Bedi. Thank you.
I did not, my lord, assist. I'll take 5 minutes on that.
Yes.
Bro, please come to my submissions 2L, page 23. Just, my lord, I am highlighting because I see some, my lord, problem. Just I am a word of, my lord, caution. My lord, the lordships are aware, as my lord, 42, my lord, 2L, L for Lakshadweep, no 42. The lordships would be going into it. I'm just bringing to your lordship's notice without reading it that this is also one more angle.
2L.
2L, L.
There's no page 42 actually.
There's no page.
223.
23.
para 24, 42,
Yes.
para 40. But sum and substance of the argument, which I, my lord, fully support and adopt, is that if there is a legislative incompetence declared by the court, then it goes. If it is held to be unconstitutional on the ground of violation of fundamental rights, it remains as a dead letter, my lord, according to them. But now there is one nuance which is not concerned, we are not concerned, but in some other matter, my lord, it might affect. One provision was declared unconstitutional under 14 and 19. It remained on the statute book. Therefore, my lord, the Parliament removed that unconstitutionality which was based on 14 and 19, and that act is upheld by this honorable court. You must kindly bear one fact in mind. So, page 23, your lordship would find all this judgment. Lord, I am not going. Keshav Rao, Madhav Menon, Peshi Kaka, etc., etc., etc. But, my lord, Blackstone doctrine, my lord, I would, in just 3 minutes, my lord, I'll be able to, my lord, satisfy your lordships. And this is accepted with some addition by Indian jurisprudence. But since your lordships would be writing on this, it may not be, it should be complete. That's the purpose. But Blackstone doctrine, my lords are aware, says that if your lordship declares a law invalid on the ground of incompetence, constituent incompetence or legislative incompetence, it relates back to the date on which it was passed, and your lordship's declaration of unconstitutionality would mean it never existed. So that is the doctrine of, that is Blackstone doctrine. For the first time, it came to be considered by Indian court in Golaknath case. Lord, your lordships would find that, I'm not reading, my lord, but at para 47, page 25, Golaknath. Lord, Golaknath case, your lordships accepted Blackstone doctrine with one exception. Since your lordships have the power under 142, your lordships decided that when we declare the law to be invalid, it would go to the root. It never existed. However, we have the power of prospective overruling. So if we say that it would be overruled from today onwards, then it would not relate back. But we are not concerned with that situation. But leave that, Lord. I am not reading the Golaknath case. Please come to, my lord, page 27, para 51. I am just giving the citations. Lord, that is Jarnail Singh versus Lakshmi Narayan, where, my lord, this Blackstone doctrine. Lord, why I am saying this? When section 4 of the Amendment Act is declared unconstitutional, it goes to the date on which it was made and it never existed. That is Blackstone doctrine. So whatever was there earlier remains. It's not a revival. The section 4 never existed. Lord, then your lordships would have para 52, CIT versus Saurashtra Kutch Stock Exchange Limited, 53, PV George versus State of Kerala, 54, Chandrasekhaya versus Jankiri. Then, my lord, M.A. Murthy, this is, my lord, a lead judgment on the point. Your lordships can, my lord, at your lordship's leisure, go through it, para 55. Now, my lord, come to page 30, para 56. Other jurisdictions have also accepted this doctrine. And that's what, Lord, I wanted your lordships to, Lord, take note of, so that when, if your lordship decides this question, it should be, our assistance should be complete. Therefore, Lord, that other jurisdictions also follow the same doctrine. I'm not reading, Lord. Harper versus Virginia Department of
Please
Taxation.
look at them, Mr.
Well, this is US. Well, thereafter, next is Supreme Court of South Africa, para 57. Democratic Alliance versus Minister of Home Affairs, well, Supreme Court of Appeal of South Africa. Then, my lord, Irish Supreme Court, my lord, para 58. Then, Lord, Australian High Court of Australia, that's the highest court, my lord, 59. Then 60, Supreme Court of Canada in so-and-so versus so-and-so. I have quoted, my lord, the relevant part. And, my lord, thereafter, again, my lord, some judgments of our court, my lords. So my respectful submission, my lord, in cases where there is unconstitutionality declaration based on fundamental rights, it remains, but it can be cured by the Parliament. But if it is either lack of legislative competence or constituent competence, like in the present case, it goes, and in any case, alternatively, as per Blackstone doctrine, it never existed the moment Minerva judgment is delivered. So these are my submissions. But as my lord, I have assured your lordships yesterday, I have put one pager, but as page 2U, volume 2U. It's one page. It's just been mailed. I'm not reading it. What is, my lord, my interpretation of Article 39D? I have already, my lord, made my submissions on that. But yesterday, my lord, I sought your lordship's permission to place that one pager. It is literally a one pager.
Thank you.
Grateful.
Yes, Mr. Shankar.
Okay, so.
Before I address you on the points which I had put in my notes and I'd highlighted yesterday, I thought I'll just respond to a few things that took place this morning. First is with reference to Mr. Dwivedi's arguments on the higher standard. I adopt what he says about constitutional or constituent incompetence. But I'd go a step further and say that as far as the basic structure doctrine is concerned, that is the very ethos of the Constitution. That's the fundamental, the Grundnorm, as it were. I don't think there is the possibility of, in any way, limiting a violation to it. If we accept that a breach of the basic features have taken place, that cannot be tolerated by this court or by this country even for a minute. What I mean is that if therefore this court declares at any point of time that the basic structure has been violated, we cannot possibly consider a situation where that basic structure violation is permitted to have continued even for a short while. It means at its fundament that constitutional balance has been upset. So restoration to its very essence, to its very genesis, is a constitutional imperative. It is a mandate. I pitch it a little higher than what Mr. Dwivedi did, because a question of legislative incompetence may permit this court, particularly with its powers under 32 and 142, to at some point carve out remedies which may permit even a legislatively incompetent law to a certain extent to be saved for whatever purpose. But not so with the violation of the basic structure. Because if it's a basic structure violation, everything has to go in my view. It's absolutely fundamental. Linked to this is the fact that this prospective overruling doctrine, which Chief Justice Subbarao heavily relied upon in Goloknath, was a pre-basic structure situation. So there he did not have the advantage, though the arguments were made by Mr. Nambiar about implied limitations on the constituent power, which was not accepted. But subsequently, when Mr. Palkiwala argued it before the case on the bench, it succeeded. So prospective overruling, whether it is available to a constitutional amendment challenge after the basic structure doctrine, is not a question that's ever been explored. But I would say it is not available. It is not available for a constituent court to say that yes, our basic structure has been violated, But today, when I am saying that that violation has taken place, I am going to save everything that took place from then till now, but not going forward.
So it goes to the root of the matter.
Absolutely goes to the root of the matter. Which is why, if you step back a bit, the way 31C stands today is that 39B and C doesn't upset the balance. But the minute on this side, apart from 39B and C, you put A, D, E, and then you put 38, 37, 30, 40, 41, etc., the balance goes. That's why Minerva Mills said, no, we can't send it that far. But maybe those two. But between those two subclauses of 39 and the entirety of Part 4, where does that balance stand? We don't know. It's not been explored. But it is because that balance gets completely upset that the basic structure is affected, which is why I would say there is no question. It goes absolutely to the root of it and it cannot be permitted even for a moment. The second, I think, just to assist, because your lordships had put a question, is there an instance where a provision has been struck down and then the legislature has taken steps? It's happened at least once to our knowledge, which is in Indira Gandhi versus Raj Narayan, 329A was struck down, where they said the election of the Prime Minister cannot be questioned. But that was in 1975, in November 1975. But in 1979, the 44th Amendment omitted that provision completely. So that has happened at least once. I'm sure there might have been instances where it has come up again. And then I'm very grateful to Justice Bindal for highlighting the oversight which is entirely mine. The provisions which have in fact been struck down by the Constitution, at least in this version, we have put them all in italics, which includes the NJSC provisions. Part 9B, cooperative societies, because 368(2) proviso was not met. Everything there went except dealing with multi-state cooperative society, or a competence issue. So we very carefully went through it and put it in the italics. But your lordships are right. We omitted to do that with the Chandrakumar provision. That's a correction that we need to do.
Not in your book only, it is there in the government publication.
No, that is there. It's there across publications. But I'm saying here at least,
Question was how to sort it out.
No,
Whether
absolutely.
they are bound to do it, as you said,
No,
29
because
they deleted.
eventually, my lords, all authorities will say ignorance of the law is no excuse when it comes to a citizen. So the citizen has to know. Exactly. There has to be some possible, maybe some PIL will be brought before the court at some point.
Deem in this case, everybody is raising this.
Yes. Correct.
So if this solution is given immediately after the judgment, the deeming arguments are not required.
I would just say, suppose there was a review petition or a curative, and then that judgment was overturned. The poor draftsman will be going erasing and putting it back, erasing.
Not that immediately next day they have to take it.
No, I know, I agree. Or there may be an overruling at a later
Yes,
stage after.
a larger bench may say
Yes,
that the striking down was bad.
correct.
Therefore, it gets revived by a judicial verdict.
I think the discipline that the publishers follow effectively is that, look, if the legislature has done something, we leave it there. The courts have taken a decision, so we'll have to put a footnote or something.
Brother Bindal, not the Gopal Shankaranayan, the senior counsel, but Gopal Shankaranayan, the editor of the Constitution.
No, but we will carry out that correction. Well, with reference to, I think, a very interesting remark that came from my Lord the Chief Justice, that what would happen if instead of saying Part 4, each of the provisions were mentioned. That was in fact done. There were 2 amendments moved in the 44th Amendment before Minerva Mills, but 2 private members had moved amendments suggesting not the entirety of Part 4, but 37, 38, 39, and they mentioned 4 or 5 others. Now, it's very interesting because if that had come up and your lordships had struck that down, then perhaps I think it would be very valid to say that the provision has no meaning thereafter. Because you've listed 39 among those.
There you are right, completely.
But that's not what happened. And there they didn't even place those amendments finally for voting.
But they would have probably struck down everything but 39B and C.
Perhaps,
Because they were bound by Keshwan.
it would
Perhaps
remain.
They may have.
39B and C would have been,
Correct.
would have
In
remained.
which case it would have been much
It was bound by the 13-judge judgment.
And
Yes.
doctrine of severability would have applied. They
Correct.
would have saved that.
Correct. It would have saved that. First, now I'll just quickly go through 2 notes I'm just telling you what my points are first. The two notes are 2E, E for extreme, not elephant, extreme, and then 2M, M for middle. So that's what the court is being called upon. 2E and 2M.
So you want us to accept 2M and discard 2E, or what is?
In a sense, so that we can have a balancing mode. So I'll just explain what those 11 points are, so that your lordships knows immediately what the sense of it. The first is with regard to the background of 31C. I think it's integral for us to understand the historical background as well. Nobody explains this better than Granville Austin in Working a Democratic Constitution. Chapter 10, I think a very interesting reading about how these three constitutional amendments came together, 24, 25, 26, and what the aims were there. Interestingly, this 25th amendment was part of a set of amendments to get around R.C. Cooper, where 10:1, the nationalization of the banks had been rejected. Now, why this is interesting is, apart from bringing in 31(2) by section 2 of the 25th amendment, it brought in 31C by section 3 of the 31st amendment, of the 25th amendment. Now, all of these were subject matter of Keshananda eventually. But what is interesting is the three things that took place. The first is that on 10th Feb 1970 is when the judgment in Cooper takes place. On the 28th of October 1971, the Law Commission goes into the draft Constitution 25th Amendment Bill to understand exactly how much of it would be approved, would be worth it, etc., etc. The members of that commission are very interesting. It was chaired by former Chief Justice Gajendra Gadkar, but